Blinn versus Carlman.
May it please the court, I'm Philip Burlington here on behalf of the appellant. I'm trying out the hearing enhancement system, which I'm not sure will enhance. So if I take it out, please.
Do you want to try a test question, or
Well, if you make it easy for me.
what is your name?
I am Philip Burlington. With me at council table is Nicole Siegel, co-counsel. We are here seeking reversal of an order that invalidated a will executed on April 2nd, 2008 by Richard Blinn. There is absolutely no direct testimony that Mr. Blinn on that date lacked testamentary capacity. There is in fact no direct evidence in the periods in the months preceding and after that he lacked testamentary capacity. The way in which the people challenging the will, which was his son and daughter, was to hire an expert to do what they called a forensic autopsy. And I am not here contending that a forensic autopsy is per se inadmissible. However, just because you call something a forensic autopsy does not make the expert's testimony admissible or entitled to any weight, because as with any expert testimony, it has to be evaluated based on the factual predicate and the rationale of the analysis. Here, Dr. Alexander, who's a psychologist, not a psychiatrist, testified that he evaluated the medical records, and the judge precluded him from making a diagnosis, but allowed him to give an opinion as to whether on that specific date Mr. Blinn had capacity to execute the will and whether he was subject to undue influence. And respectfully, that was error, should not have been admitted. Dr. Alexander admitted that there was nothing in the medical records from 2007 and 2008 that indicated that Mr. Blinn lacked testamentary capacity. What he did was he found in certain medical records, and there is evidence that there was that Mr. Blinn was getting a drug called Aricept, which is used for dementia. However, we know that you can be insane and execute a valid will if you have a lucid interval. We also know from this court's decision in Estate of Hammerman, where the testator executed a handwritten will on the day that a successful Baker Act petition was filed against him, and it was upheld because it was determined he had a lucid interval. How do we know Richard Blinn had a lucid interval? Well, the lawyer who drafted the will sat with him, asked him questions, testified it was their policy to evaluate people executing wills, testified that he was alert, he was responsive, he knew the effect of the will. The lawyer said he reviewed the will with him. He noted that his children were being excluded, specifically asked him if that was his intention, and he said yes, and there is no testimony to the contrary. We also know that Mr. Blinn was referred to that attorney by another attorney named John White, who had done business law for Mr. Blinn in the months preceding and the months after the execution of that will. And he testified that, in his opinion, Mr. Blinn had testamentary capacity throughout that entire period. And perhaps the most damning and uncontroverted evidence is that 4 months later, Richard Blinn's son, Brian, had a meeting with Richard alone. Faye was not there, with an attorney in New Hampshire, and they discussed business matters, and Brian specifically suggested that Richard execute a new will. So how can Brian come into court here and testify, as he did, and claim that 4 months earlier his father did not have testamentary capacity, when 4 months later he specifically suggested that his father execute a new will and his father declined? There's no question that Mr. Blinn was ultimately diagnosed with Alzheimer's, and it became severe, and he died. That was over 2 years later after the execution of the will. And the courts have consistently recognized that if there is evidence that the person was lucid at the time they executed the will, it doesn't matter if they have previously been determined insane. You can look at the estate of Edwards case. And if you look at, as I said, the estate of Hammerman case, you can be determined incompetent. But if you had a lucid interval, and there is no question that in the years preceding and years after, Mr. Blinn did have lucid intervals. And on the undue influence, which I have to win on both of these, they failed in their burden. Now, this is a wife, and therefore they are not entitled to a presumption of undue influence simply by proving that she obtained it, where she was a substantial beneficiary, she had a confidential relationship, and that she procured the will. There is absolutely no evidence that Fay procured this will. Neither of the attorneys, either the one who referred Mr. Blinn to Mr. McMahon or Mr. McMahon, said they ever spoke to Fay about the will prior to its execution. She testified she did not discuss it with him. There is no documentation to that effect. Mr. Fay drove Fay and himself to the meeting, so there is absolutely no evidence of the procurement. And in the estate of Carpenter case, Florida Supreme Court identified 7 factors in evaluating undue influence. 6 of those factors, based on undisputed evidence, do not exist here. The only one of the 7 that exists is that Fay was present when the will was executed, but of course we know they were reciprocal wills. And she was approximately 88 years old and he was 82 years old. So the fact that they did reciprocal wills is certainly no indication that the disposition in itself unfavorably favored her in a way that indicated undue influence.
I have 2 questions for you. One is the first is, and you can answer them together, is this is a case that was a trial, right?
Correct.
And the trial judge made a lot of findings specifically. Correct. And the trial judge, for those findings that she didn't make specifically, we're entitled to assume that she made findings against your client. So that's one. Number 2 is with respect to undue influence. It seems to me that the most powerful evidence of undue influence was the mistaken phone call that your client made to the office of her former husband's business. And that testimony, which was, which I think the trial judge believed, really showed someone who was incredibly controlling and angry. And it's usually in these types of cases, you don't get a glimpse of how the parties interacted together because an undue influence, the influence usually occurs behind closed doors. Correct. Here we have a glimpse of what she was like. The trial judge.
Well, Your Honor.
The trial judge, let me finish my question. The trial judge could have presumed that that's what she was like. And that casts a whole different light on all the other evidence if the trial judge believed that. So that's the problem. I think that's a difficult thing for you to overcome.
Okay, Your Honor. First of all, that evidence is nothing about active procurement, which is an essential element of undue influence. First of all, what you're talking about is a conversation with a former salesman at Sovereign Yachts, which was a business that Mr. Blinn owned. And he testified that he had a phone conversation with Fay, and then he believed she thought she had hung up, and she was clearly angry about Patty. And there's no dispute that there were problems between Fay and Richard Blinn's 2 children. The fact that she was angry at Patty on that day and felt that Patty was taking advantage of her husband is not evidence of active procurement, and they were not even able to place it before the execution of the will. So if we are going to say that any time there is animosity between a spouse that is not the mother of the other spouse's children, and that in itself is enough to invalidate a will for which there's a presumption of testamentary capacity and there's an element of required procurement, then I submit that evidence is incompetent to support a determination of undue influence. There are many cases where the estate of, and I'll mispronounce it, Flohl, is one where the son claimed that, and it wasn't even a wife, it was a girlfriend of his 82-year-old father, and they went down and did reciprocal wills, and there was animosity between the son and the girlfriend. But animosity in itself is not sufficient for active procurement or for setting aside a presumptively valid will where you don't have any evidence of lack of capacity on the day it was executed.
What are the, I mean, in the cases that have found that there was, 'cause I'm going to set aside the testamentary capacity, so I'm not talking about that. But in the cases that show undue influence, what are the common fact patterns that the courts have found sufficient to
All right,
show
in the
undue
Carpenter
influence?
case, they identify 7 factors, and none of them will be some evidence of animosity. These are the 7. The beneficiary's presence at the execution of the will. No question. Faye was there, but they were reciprocal wills. Second one, beneficiary's presence when the testator expresses a desire to make a will. There's no evidence of that. The evidence is that Richard contacted Mr. White, who was his prior attorney, said he wanted to do a will, and Mr. White referred him to Mr. McMahon. Number 3,
But there's no evidence that she's not there on the other side of the phone call, right?
Well, there's no evidence whether it was in person or in a phone call. There is simply no evidence. And they have the burden, and we have a presumption not only of capacity, which relates to undue influence. I mean, here, Dr. Alexander was all talking about lack of capacity, and he said, well, and because of that, he was subject to undue influence. I mean, they go hand in hand. Number 3, beneficiary's recommendation of an attorney to draw the will. Undisputed, that's not here. The next one, the beneficiary's knowledge of the contents of the will prior to execution. There is no evidence of that. The beneficiary's instructions to the attorney on the preparation of the will. There was confusion among Mr. White and Mr. McMahon as to who counseled Richard as to the will. There's no question McMahon drafted the will. Neither of them had any conversations with Faye, and so that element is not present. Okay, next one. Whether the beneficiary secured the witnesses to the will. Absolutely no evidence. Last one, whether the beneficiary has possession of the will subsequent to execution. We know that subsequent to it, she contacted McMahon for a copy of it, so she did not have it, and I would like to reserve the remainder of my time for rebuttal.
One question though on lack of testimony capacity.
Oh, I'm
before you
sorry.
said- Yeah, I just have one. Wasn't there some evidence? Did I do that?
No, I did that. This thing is, sorry.
Okay.
Just speak up and I'll do my best to hear you.
Wasn't there some evidence that Mr. McMahon, the attorney who drafted the will, really didn't discuss with Mr. Blinn anything about his understanding about the extent of his assets, his children who he was cutting out? Wasn't there some testimony that the attorney only spent about 10 or 15 minutes with him and never really went into all of these areas that we would look at to determine whether or not he lacked testamentary capacity? Wasn't there some evidence to that effect that he never actually sat down with him and went over these essential areas to
Okay,
determine?
you're talking about when Mr. McMahon met with him?
Right, when he met with them, when they actually executed the will.
Right. What Mr. McMahon said was, and this, page 29 through 30, Richard was alert and responsive. Page 43, McMahon reviewed the will with him. Richard understood the effect of the will. McMahon testified the policy of the firm was that when a testator excluded children from a will, the firm made sure the person was aware of what they were doing, and Richard confirmed that what he was doing. What they rely on, they say, well, Mr. McMahon, did you ask him how many children he had, or their names? And Mr. McMahon couldn't remember whether he did or not. That's not required, whether you're disinheriting 1, 2, or 20 children. The point is, that was his intention, and he was answering the questions. Mr. McMahon said he saw no signs of undue influence, and he would not have proceeded if he observed either lack of capacity or undue influence. He said in the conversation it was about 40-60 as to talking to Richard and talking to Faye. So that is not enough to set aside a will where there's a presumption that the testator has capacity. And there's no suggestion at all that Mr. McMahon's testimony was that Blinn failed to answer any question correctly or showed any signs of dementia, delusions, nothing. They just want to pick holes in the specific questions, but testamentary capacity only requires some idea of your property, and no one's ever contested that the will addressed all the property and that his children got life insurance proceeds. I mean, there wasn't like something was left out. They asked about his children, and as he explained, he reviewed the will and he understood the practical effect of it. And those are the elements, and I hope I'll be given a little mercy for some rebuttal. Thank you.
May it please the court. I'm Rebecca Vargas. I'm here on behalf of the appellees, Patty and Brian Blinn, who are the adult children of Richard Blinn. With me at counsel's table is their trial attorney, Theo Kypris. First, turning to the testimony of Dr. Alexander, we've heard a concession from Mr. Burlington that this type of testimony is admitted, thank you, sir, is admitted and is a technique that's been approved by this court in Jackson versus State and also in Sison versus State. That really leaves the question of whether or not Dr. Alexander had a sufficient factual basis for his opinion. In this case, he did. That's the sufficiency of the factual basis of the expert's opinion is well within the trial court's broad discretion. Here we had an expert who reviewed 10 years of medical records. He traced the increasing confusion and dementia and diagnosis of dementia. In 2006, he was taking Aricept for dementia in 2006. 2 years later, he was admitted to a hospital in Massachusetts, January 2009, only 8 months after signing the will. And again, he was diagnosed with dementia upon admission in the hospital. The fact that he discounted the testimony of the internist, Dr. Herman, is not a basis.
Let me ask you this.
Sure.
So I think that's admissible. The testimony is admissible, but the question is really how much weight should be given to it. And the point I think that Mr. Burlington makes is that, okay, he has these problems, but the problem for testamentary capacity is that, even someone with some type of dementia, some type of mild dementia that's progressing and gets worse, can have a lucid day. And the question then is, the lawyers testified. There's no direct testimony that, that on the day that he executed the will, that he was having problems, and the lawyers, the testimony of the lawyers really either they didn't remember or supports that, and as like I said, the burden is on you. So assuming that testimony is admissible, I wouldn't waste time on that unless the other judges have questions, of course. The question really is the evidence sufficient, even assuming that there's some testimony that he had dementia, to overcome the presumption and to overcome the types of things that the Supreme Court has said you need to have to show undue influence.
Well, thank you for that direction, Your Honor. I think the first thing to point out is that it is not our burden to show a lucid interval on a particular day. The case cited in the reply brief is simply bad law. It's the Weehee case out of the 4th District, which was quashed by the Florida Supreme Court, and both parties had cited the Florida Supreme Court decision in Weehee in their initial and answer brief. So I invite you to look at that. In that case, the Florida Supreme Court said when you have a testator with a progressive disease, which is what we have here, we have someone who is undisputed, he had Alzheimer's, and it was Alzheimer's disease, and it was progressive. If you've got a progressive disease, and Weehee and Zimmerman, the Florida Supreme Court held, you can admit evidence before signing of the will and after signing of the will, and you do not have to disprove the lucid intervals theory. And so in Weehee, what the Supreme Court did is reversed the 4th District because they said the 4th District had improperly reweighed the evidence and applied the wrong burden because you don't have to disprove a lucid interval when you're dealing with this type of a progressive disease. So that would be my first point. And also to remind the court that this is really a very fact-specific inquiry. The trial judge was in the best position to evaluate the credibility of these witnesses, weigh the conflicts in the evidence, and she simply did not believe Faye's version of events. She had multiple inconsistencies. Yes, Your Honor.
What evidence did the trial court rely on in finding that Faye exerted undue influence on the testator, on Mr. Blinn?
Okay. As to undue influence, she found, first of all, again, the Faye is applying the wrong standard as to undue influence. According to Faye's reply brief, we have to show active procurement and the Carpenter factors. However, we had conceded below that this is not a confidential relationship because they're husband and wife. The law does not apply a presumption, but several cases, including Blitz and Targassian, both held that even in that type of relationship, you could prove by a preponderance of the evidence, looking at all the factors, that undue influence occurred. And what the court considered here is the fact that Faye had the opportunity and motive in order to exert her will over Richard, and that included the fact that she paid all the bills. She also...
Well, what facts show that she actually exerted undue influence over the testator?
Well, the court also said that there were other nuances of her behavior, so that's a clue that the court was really evaluating her credibility and all the evidence, like, for example, the phone message from the employee where Faye did not know that she was being recorded and left a screaming and profanity-laden message saying that the daughter, Patricia, was a thief. That goes to show the alienation. She kept Richard from his children. And also, he had a diminished physical and mental capacity. We know that because there are diagnoses. He had been treated for depression and anxiety and then dementia.
What about the 7 parts of the Carpenter test that Mr. Burlington references? I mean, his point's well taken. If every time there's, disgruntled children, disgruntled family, that there's undue influence per se, then we're going to have a lot of undue influence cases. So explain how specifically, and his specific reliance on the procurement of the will as a factor that we should be guided by.
Well, we do have evidence of procurement here. It's not our burden, but we have evidence that was conflicting, that Faye, who had lent money to this attorney, John White called his former law partner at the Grantham firm, at the Grantham firm, it was Faye who had corresponded with the Grantham firm, not Richard. They had a copy of her prior will, not Richard's, and they had, after the will, she sent them unsolicited letters, Dear Doctor letters, saying that we were of sound mind 7 months ago. And then in 2011, when Richard was diagnosed with severe dementia, she attempted to call the same firm and have them execute new documents in her favor. So all these factors taken together, and there was a conflict because although Mr. Burlington has represented that the attorney who executed the will gave him legal advice, the trial court discounted that testimony because they met for 10 to 15 minutes. He had not given him any legal advice. He had sent the draft back to Attorney John White with a cover letter to make clear that he had not given these clients any legal advice about the drafting of the will, and he did not discuss their assets, he didn't discuss their family, he didn't discuss, those typical things that you would discuss in order to determine that somebody has capacity to make a will. And Attorney McMahon himself admitted that he was uncomfortable with the representation for that reason, because he always has that type of a client meeting. They discuss the terms of the will, he goes back and drafts it, and then they come back and execute. That didn't happen here. And it was for the trial court to resolve these inconsistencies. She claims she didn't know anything about the will, but the documentary evidence refutes that, and it shows that it was really Faye who was procuring this will. And that's only one factor. So this is not a case of a Carpenter presumption. The act of procurement is not the be-all and the end-all. It's one factor that the court considered.
But like what you're saying is that there are suspicious circumstances. Okay?
Right.
And in criminal law, I don't know if I don't even know if it applies in civil law. If there's another reasonable explanation for a defendant's conduct, that sort of undercuts the power of circumstantial evidence. I mean, there's no real direct evidence of in this case of undue influence, except the screaming incident. And the question is, in any of the cases finding undue influence, have any of the cases relied on as many inferences as you want us to rely on here?
Well, Your Honor, the In re Carpenter's estate case recognizes that this type of inquiry, undue influence, is almost always proved by circumstantial evidence because this type of undue influence occurs in the dark and in secret, and that's why the trial judges presiding over these probate cases are given the broad discretion to evaluate the many nuances of the witness's behavior. And in this case, there was many things that added up to this finding of undue influence, including the fact that this was a departure from Richard's prior estate plans. In the past, he had left, his wills varied a little bit, but he either gave them to both. His beneficiaries were either both his children or one child, and even though he was involved in a long-term marriage, he had only been married to Faye for 8 months at the time of signing this will, so it was a big departure. You've got the alienation factor, where she was separating Richard from his children. I think the In re Lamberson's estate is a very good case for this court to look at as far as similar factors where you've got evidence of that type of isolation and alienation and just the motive and opportunity and the ability to assert undue influence. We cited several other decisions in our brief, including the Kripe case, the Atz case, the Gardiner case, the Newman case, and it's really an interesting area of law because they look at many factors, and that's why it's so fact-sensitive.
Well, what
Yes, Your
evidence is there, though, that Faye was the one who actually turned him against his children and that she was the cause of his disinheriting the children? What direct evidence is there of that?
Well, Your Honor, we do have the voicemail that we've discussed already to the employee. We also have loan applications that were in Faye's handwriting where she was making applications for a loan to the bank where she was basically saying, Richard's, we're in this terrible situation where we need a modification because Richard's children are stealing from them and they're ruined his business. But we know from the unbiased testimony of the employee that was really not true. Patty had not been stealing from Richard. She was helping Richard to recover from his own imprudent financial decisions. Starting in 2005, he just started to make quite a few bad financial decisions for the business, and that's the reason the business was in financial trouble. We also have the testimony of both Patricia and Brian that she was turning their father against them. She prevented Richard from attending Brian's wedding, and they started to refuse to see them, to accept letters from his grandchild, who he'd formerly had a very good relationship with. So once you take all these factors together, it adds up to a finding of undue influence where she exerted his will.
Do you think that we have to find that the two arguments are sort of intertwined for us to find undue influence or to affirm the lower court's decision on it? We also have to find the lack of testamentary intent, correct?
No, Your Honor. Actually, they're very separate. They're very separate findings.
Let me just so to complete my thought, if the idea of undue influence is substituting your will for the will of the person whose money is involved, therefore there has to be a diminution of that person's will or intent. So we have to find some, if not, every time you get remarried and they have a disagreement with the kids, which seems to be a reoccurring theme, that doesn't mean that just because they say that means there's an undue influence, does it? I mean, don't we have to find something about that his will was so lessered that he was able, that the wife was able to overcome his will for her will?
Well, the inquiry here is whether competent substantial evidence supports the factual finding that the making of this will was really the will of Faye, that Richard's own will was overpowered because he had a decreasing mental capacity, physical capacity. She was isolating him. She was alienating.
There's an overlap of the two issues.
There is a little bit of an overlap, but these were really alternative findings because the capacity issue is a bit different. The capacity is, did the testator have the ability to understand his property? Could the testator understand the nature of his assets? Could he understand who was the natural bounty of the will? And in this case, we had abundant evidence that he did not meet any of those criteria because he was under the false impression that Patty was stealing from him. He was playing mail-away scam lotteries and sending $300 a week to Australia and New Zealand, and he thought he was making significant amount of money. He was not making anything. He dissolved his charity, My Greatest Dream, only 4 months after making it the remainder beneficiary. Those are all factors to show that he did not understand what he was doing when he signed this will. Now, conversely, as to the undue influence finding, there's not a requirement of lack of capacity. Instead, the fact that you have a diminished mental ability or physical ability is just one of many factors that the court can consider. So in the undue influence, it is a different, you don't need to find undue influence in order to have, conversely, lack of capacity is not a requirement of undue influence. Instead, it's just the diminished mental state could give you the reason, could give them a way to make you more susceptible to undue influence. And that's what Dr. Alexander...
Have testamentary intent, but still have a diminished will, therefore being undue influenced by this other person.
That's right, Your Honor. Thank you. With that, if there's no further questions, I'd ask this court to affirm the final judgment invalidating the April 2008 will. As Mr. Burlington has conceded, it's his burden to show no competent substantial evidence for both lack of capacity and undue influence, which he's failed to do. We ask you to affirm. Thank you.
There was an error of law stated here. Active procurement is an essential element of undue influence. It is not a mere factor. And we've cited case law, including the Carpenter case out of the Florida Supreme Court. And there is no evidence of that. This suggestion that 3 years later, when Richard did have significant mental incapacity, and that Faye went back to the attorneys that she had dealt with 3 years before, is not an indication that she procured that will 3 years before, when both of those attorneys said they didn't talk to her, and she said she didn't talk to them.
So what you're saying is that it just seems like Judge Lewis did not believe a thing your client said. And assuming that Judge Lewis found your client to have no credibility whatsoever, why isn't that enough to spin the evidence in a way to affirm the final judgment? I mean, Judge Lewis just wasn't impressed with your client. I mean, that's a finding of fact because she evaluated, she was there evaluating the testimony, and also the lack of testimony really from the lawyer who drafted the will as to, he had no memory as to really what happened, and she didn't seem to give him any credibility either. So assuming that that's true, why isn't, in terms of weighing it, why isn't that enough?
Because of the presumption of capacity, because of the presumption that a testator is authorized. You simply can't set aside a will because you don't trust somebody when you don't have evidence of active procurement. And that is clear in the case law. And I would add that Faye did nothing to interfere other than that she, on religious grounds, did not agree to Brian's marriage to a man. But Brian testified he had complete contact with his father. He was on good terms until the day he died. If you look at page 568, Patty testified she does not have any personal knowledge that Faye did anything to prevent her from contacting her father. Yes, there was some animosity. There's no testimony that the reason that Richard did not include her in his will, and by the way, he didn't have Brian in the 2006 will at all. He had Patty, is because there was life insurance and because he and Faye had reciprocal wills. And there's no indication. And what the judge found was, she said, I find that Faye had opportunity, motive, and demeanor to exert undue influence. Well, no offense to the marital unit, but you can say that about any marital couple. And that's why the case law that deals with when a spouse is accused of undue influence makes it very clear you have to have more than just saying that one spouse influences the other, one spouse has, an interest in what is going on in that person's life. The fact that the children were not included, they weren't left destitute, and it's undisputed that he paid Patty a salary out of his personal pocket because, and so, obviously Faye felt that was perhaps inappropriate. But I need to make a few other very quick points.
Very quick,
Yes.
wind it up.
Jackson v. State is the only one where this court allowed a forensic autopsy, and that was simply on the question of whether a minor suicide back up. The mother conduct was a substantial factor in the minor suicide. It was not going back to a specific date and evaluating somebody's mental capacity on a specific date, especially when Dr. Alexander admitted nothing in 2007, 2008 medical records indicated Richard lacked testamentary capacity. Finally, one of the things I want to point out is McMahon's testimony, while it was years previously and he had done many wills, it was very clear that he went over it. And this suggestion that 15 minutes is inadequate to evaluate this, the two of us have been in front of you now for 15 minutes. I would suspect you can determine whether we have the capacity to do, and it is admittedly in the law and Dr. Alexander's testimony, a low bar, testamentary capacity. There is no requirement in ethics or law that there is a neurological examination. The only thing Mr. McMahon was uncomfortable with was Mr. White, he believed, had given the legal advice, but he was the one drafting the will and sitting with the person. He said he would not have done it if he saw any signs of lack of capacity or undue influence. And I submit that if you allow it simply because of animosity with children, you really are eliminating the essential requirements and undermining the relationship of spouses, which is inherently confidential and influential.
Okay, thank you very much, Mr. Crowe.